Hey guys, welcome to this YouTube channel where hedging peso matters. So sa pagkakataong ito, mag-uusap po tayo ng mga bagay na naaayon sa batas. And here we are in the segment kung saan kaso mo, ikwento ko. And for today's case, we'll be discussing the case of Figuracion Gerilla versus Viuda de Figuracion. So let's go first with the facts. So, si Leandro and Gerilla, so ano po sila? Mag-asawa sila. And they have 6 children. Yun sina Elena, HILARIA, FELIPA, and Mary. Alright? Now, etong si Leandro, nag-execute siya ng deed of quitclaim over his real properties in favor itong sa 6 mga bata, sa 6 children. So ito yung lot 2299 and lot 705. Ngayon, itong lot 2299, yung portion nun binenta kay Lazaro Adviento. Pero yung tax declaration continued to be in the name of Leandro. Alright? Si Leandro yung tatay ng 6 na bata. Now, what gave rise to the complaint for partition was a dispute between Elena and Mary over the eastern portion of lot 707. Pero itong lot 707 na ito, this belongs to Eulalio Adviento. Of course, evidence ito ng certificate title, okay? Now, nung namatay itong si Adviento, yung kanyang mga daughters, kanyang mga anak. Si Agripina, anak niya sa unang asawa yon, and si Gerilla, anak niya sa pangalawang asawa. Sila yung nag-succeed sa kanya. Now, itong si Agripina naman, nag-execute siya ng quitclaim over dun sa 1/2 portion ng eastern portion ng lot 707. So, namatay si Agripina, and mabuti naman na walang issue. Nung upon her death, walang issue. Now, subsequent to this, itong lot 707 was sold to FELIPA and HILARIA. Syempre, ang nagbenta na nito si Gerilla kasi nagkaroon siya ng affidavit wherein she adjudicated that lot 707 sa kanya as the heir. Of course, hindi niya may bibenta kung hindi siya yung owner. So, siya na yung naging tagapagmana. Binenta niya tong lot 707 kay FELIPA and HILARIA. Ngayon naman ito, si Elena sought the extrajudicial partition of all the properties held in common by her and the respondents. Yung respondents, yung iba niya pang mga kapatid. So Elena filed a complaint in the Regional Trial Court of Urdaneta for madami siyang final. So isa dito yung partition, annulment of documents, reconveyance, acquiring of title and damages against the respondents. So the respondents took the position that Leandro's estate should be first undergo settlement proceedings before partition among the heirs could take place. Ngayon, ito rin yung naging issue sa kaso nito, whether or not yung estate ba should undergo a settlement proceeding first before the partition among the heirs could take place. Now, sabi ng court, nung it came to the knowledge of the court, ito ang sagot ng court sa kanila. Alright? The right of the inheritance is transmitted immediately to the heirs by operation of law. And at the moment of death of the decedent, nata-transfer na yung rights. Alright? The rights to the inheritance, nata-transfer na agad. Now, ang dito, there is no doubt as one of the heirs of Leandro Figuracion, yung petitioner nga, has a legal interest in lot 2299. But ang tanong dito, ganito can she compel partition at this stage? Ito ang sabi ng court. Alright? There are 2 ways by which a partition take place under Rule 69. Una, napagkasunduan nyo by agreement. Ngayon, pagka hindi naman na-reach itong agreement na to, through commissioners. So, under the same rule but section 3 to 6. Now, dun sa section 8 ng Rule 69, nakalagay dun, Section 8, Rule 69 provides that there shall be an accounting of the real property's income, so kasama dito yung rentals and profits, in the course of an action for partition. So ulitin natin, magkakaroon din ng accounting ng real property's income in the course na meron ka nag-file ka na action for partition. There is no provision for the accounting of expenses for which property belonging to this decedent estate may be answerable. Ano ba to? Like yung funeral expenses, inheritance taxes, and similar expenses enumerated in Section 1, Rule 90 of the Rules of Court. So, in a situation where there remains an issue as to the expenses chargeable to the estate, partition is inappropriate. So, hindi proper remedy ang partition kapag merong issue as to the expenses na pwede mong i-charge dun sa estate. Kapag meron ka pang pwedeng kunin doon sa estate na gusto mo dun i-charge, inappropriate na remedy ang partition. So, sabi nga dito, sabi ng court, the heirs have to submit their father's estate to settlement because the determination of these expenses cannot be done in an action for partition. So, hindi naman, syempre may mga claims nga na meron ka pang pwedeng i-charge against the estate para hindi nyo paghahati-hati ang mga magkakapatid. So, i-charge nyo dun sa estate. Like yung kunyari may medical expenses or funeral expenses. Yung mga nakalista dun sa Section 1, Rule 90 ng Rules of Court, nandun yung lahat ng list, no? Kapag may chargeable siya sa estate, hindi appropriate na remedy yung partition. So, undergo ka muna ng settlement proceedings. Alright? Kasi ito, further said ng court, in estate settlement, alright? In estate settlement, there is a proper procedure for the accounting of all expenses for which the estate must answer. Alright? Ulitin natin. In estate settlement, there is a proper procedure for the accounting of all expenses. Ito yung operative word dyan. Yung accounting of all expenses for which the estate must answer. If it is any consolation at all to petitioner, the heirs or distributees of the properties may take possession thereof. Pero may kondisyon. Alright? Pwede mong kunin yung property, you can take possession over the property kahit hindi pa nasa-settle yung accounts. Ang kondisyon, as long as they file a bond conditioned on the payment of the estate's obligation. So, this is our case kwento about Figuracion Gerilla versus Viuda de Figuracion, and I hope sana nakatulong po ito. And again, thank you.